have attendees that are international. And so some of them are asleep right now.
Of course.
So yeah, so that is the story there. Well, I'll just give you a very brief introduction. So John has a fascinating background. You'll notice he is an Esquire. He did go to law school after he had a fascinating career at with MIT. So I think he did study computers, right?
Yes, computers, media, arts, and sciences. I was at the Media Lab.
Man, so you run a consulting company now, but you have such a very interesting expertise niche. And so that is why I asked John to come and talk about digital forensics. What is that? Mobile devices, we all have one. How do we protect it? How is crime solved, et cetera? So I'll go ahead and turn the time over to you then, John.
Well, thank you so much, Amanda, for the introduction. I greatly appreciate it. I'm hoping to talk to you for the next hour or so about digital forensics, specifically what we call mobile device forensics, and to introduce you to the topic. But then I want to pick up where Nancy left off, because we do a lot of work with post-conviction evidence. And so I'm going to sort of position mobile device evidence in that perspective and discuss a case study, actually. And then I want to take you through another half dozen case studies about mobile evidence and how it is making such a difference today and is in a sort of disproportionately large amount of evidence that are heard in court cases, much like DNA was for years and years, and DNA still is, but mobile is really on the rise. And so in both criminal and civil cases. And so that's kind of my agenda. I'm happy to answer questions along the way. I'm hoping there are some. I've got a bunch of slides and I'm going to kind of go through them fast, and I'm not going to read them or talk about all of the stuff on them, but you can take advantage of these slides later if you're looking for concepts or language or what have you. So let's get rolling. I guess I'm going to start by saying, why mobile evidence? Why is mobile evidence compelling today? Why is it important? Why is it, does it have this disproportionate share of the judiciary's attention at trial? And I have a couple quotes here. The first one is actually pretty ancient. It's almost 10 years old now, but the Deputy Attorney General in California calls it a personal diary. That's kind of old terminology. The Economist, a few years after that, maybe 2013, 14, basically says that really it's an intimate extension of one's life, because you take it with you almost anywhere, and now it really is literally everywhere, anywhere, all the time. And then lastly, the former chair of Google actually says, really, your phone is your alter ego. It's an extension of what you do, who you are. And having examined hundreds of these things since 2008, when we got started, it really is. It's absolutely incredible, the insight you can obtain into an individual and their motivations, their activities, by looking at a mobile device. And over the years, the sort of the range and the complexity of the evidence has dramatically increased. Back in 2008, when I got started, it was just those old flip phones. You could get the contacts and there would be a mobile number in there, maybe an email address, a name, that was kind of it. Now there's 50, 100 different data elements inside a contact record on an iPhone or an advanced Android phone. Very different. So it's compelling. I also was taken by this quote from a med student who basically says his phone is a reflection of him, right? It's a copy of his brain. And it's kind of true from looking at so many phones for so long. And so it's really, it's probative. It can be not only relevant evidence, but material evidence in so many different kinds of cases. I call them different sort of fact patterns or vectors of proof that can be provided by a mobile device. So a few quotes. Craig Ball is a distinguished e-discovery and forensics examiner who I know well. He basically says we're kidding ourselves if we don't think that evidence is in phones and tablets. Lawyers typically go to documents, they go to computers, they look at email. They still think email is kind of the center of the world, but it's really not. And Craig, of course, is a practicing trial attorney in addition to a computer and mobile forensic examiner. And so we really have, in the past 10 years, moved on from traditional computers and email to mobile devices, apps, text messages, WhatsApp, Instagram, all the rest. Another friend of mine, Gary Kessler, major forensics guy, he actually is compared and measured that we get much more probative evidence per kilobyte, per megabyte, per terabyte, really, on mobile devices than we do on computers. So computers are not passe, but computers are very much a sideshow these days.
Hey, John, quick question.
Yes.
Can you define probative for those of us that haven't been to law school?
Oh, sure. Probative goes to the depth, the sort of the precision and accuracy, the advanced precision and accuracy you can get by digging deeper into a mobile device. We take what are sometimes called images or extractions of computers and phones, and they're sort of superficial extractions. They're sort of normal or sort of run-of-the-mill extractions, and then you can get much more deep extractions. These days, we call them full file systems. And then perhaps the most maximum extraction is a physical extraction, every single bit and byte on the device. And that is a deeply probative extraction from which one can recover the maximum amount of artifacts, which are sort of the types of evidence like text messages and contacts and photos and videos and all the rest. So probative is a big deal. Probativeness, the noun, is actually a word. And we use it a lot because it's a major best practice. Really, it's a critical success factor required to get the maximum amount of both live and deleted evidence that is material to one's case, so that you have a good shot at winning your case and prevailing in a court of law. Good question. Keep them coming.
Thanks.
So this is what some of the equipment looks like. These are some of the tools that we use. We have a whole bunch of tools in our lab. One of the catchphrases of mobile device forensics is one tool is never enough. So you see here 4, 5, 6 tools, different kinds of tools, and we win cases because we'll take 5 tools at a mobile device and not just use one tool. But it's a powerful capability. It's way better than what we used to do back in the old days, 10 years ago. Even it's still done a little bit today. The cell phone service provider business records are provided, the Verizon records or the AT&T or T-Mobile records. But it turns out mobile device forensics is a really breakthrough approach in comparison to the old CDRs, called detailed records of the SMS logs, text message logs. And the reason is that we can get deleted evidence that you can never get from Verizon. You can also get attachments. You can get a lot more metadata. And there's really no comparison. So mobile device forensics is where it's at these days. And especially because of the deleted data, this describes that, kind of going through the probative levels here. Right at the bottom, you see live, not so probative, deleted, but remembered. Yeah, that's pretty good. Unallocated, forgotten, that's even better. So we are always hoping to be most probative by getting into unallocated storage, getting the evidence not only deleted, but it's totally forgotten. It's floating around in the Pacific Ocean. Those are the fragments and the traces that we want to get forensically. But there's problems. Mobile device forensics is not easy. It's not for the faint of heart. There can be hardware damage like you see here. And the screen usually is not so bad, but there's all kinds of other things that can be broken as well. So we do advanced repairs, and we have advanced hardware techniques to get extractions of the evidence from the phone, things like JTAG, chip-off, and ISP, which we'll talk a little bit about later. But locked passcodes are a huge deal. Right, recovering a locked passcode is a real problem and can bar you from getting access to a device. So we have tools that allow us to in some cases, we can recover the passcode, but quite frankly, it's just as good to disable it and then get into the phone, or even better yet, just bypass it altogether. So we have tools that use all those techniques to try and get past the passcode and get to the evidence itself. And then, of course, there's these prepaid phones, burner phones, which are a challenge sometimes. You see them involved in criminal cases, sometimes drug dealers, sometimes you use a burner, but we have advanced techniques now to get into some of those as well, bootloader techniques and chip-off techniques and others. So it's fascinating, but these glitches, these problems come up, and we have to have solutions to get past the glitches so we can get into the phone. So questions, we've already had a few, so feel free to ask questions as we go along. I've got way too many slides, so I can't stand to hear myself talk for more than a few minutes. So I'd love some interruptions.
So Gayatri wanted to know about the different machines that you have in your lab. Are you going to kind of talk about that in some of the slides? What they?
I could. They're mobile device forensic tools. We used to have hardware tools back in 2008, 2009. That's all over now. We use traditional Windows PCs and Macs, right? MacBook Pros and to do our work. It's all software now. The mobile device forensics, we have these very powerful software tools that we can use to extract the phone, then to analyze it, and then generate the kinds of reports from the tools that investigators can use, whether they're law enforcement or whether they're private investigators like I am. And so it's advanced software is what we have here. I've actually, I teach the bar associations here in Minnesota and in other states as well. And sometimes I've got about a dozen different presentations I give, a few of which I've drawn from to put this together. But one of my presentations, I just do a demo for an hour. One of my favorite tools is called Oxygen Forensic Detective. And I just do a demo of Oxygen for an hour and sort of show how we go about the business of analyzing the messages and the photographs and the timelines that we build and the maps that we create. So it's kind of fun to do a demo. So maybe if I come on some other time in the future, I can actually do a demo of how this stuff, what it looks like, because I can project it real nicely on Zoom.
Oh, cool. Note taken.
The discoverable evidence that we can get, this is sort of the short list. When we first started, it was pretty much just contacts like you see here in the middle. Then we started getting some text messages and calls. So we had calls and texts and contacts, but then the list has gotten way more dramatic here. And you can see that we can pretty much get everything now. And here at the bottom, of course, the most important word on this whole slide is apps at the bottom. It's all about the apps now. And the tools that we have now can parse or carve or decode whatever verb you want to use. Over 1,000 different mobile device apps now, which is really powerful. And so it's we've come a very long way, and the field is moving so incredibly fast, which when we start talking about post-conviction work, that's one of the key elements that makes it so important in post-conviction is the fact that there's so much innovation and it's moving so fast.
Hey,
we
John.
can also get metadata. The metadata is the data about the data. You can have a text message, but you really need all of the other stuff about that text message, right? The date and time stamps, like you see here at the bottom, smartphone content. You really want about that text message, you want the date and time stamps, maybe even not only the date and time stamp of when it was sent, but the date and time stamp of when it was received, the date and time stamp it might have been read, and the date and time stamp, if you can get it, which is rare, when it was deleted. And then geolocation information has become the latest and greatest powerful form of metadata where we can get a lat long, a track point for when that text message was sent or when that iMessage was received. And so that's really critical these days to get a date and time stamp for each artifact or to get a geolocation for it. So lots of metadata. It's all about the metadata, quite frankly. When I testify in court, it's as much about the metadata it is about the individual artifact items.
Hey, John.
Uh-huh.
I've got a question about whether you can get retinal data off a phone or fingerprint data.
I've never gone looking for it. Retinal data and face images and fingerprints typically are used to authenticate the user so as to be able to log in. It's sort of a substitute for a passcode. I've never gone looking for it. I bet I could find it if I tried. It's never been material to a case, and that's pretty much how it goes. If I know a lot about the evidence for cases for which I have been working, and I may be ignorant on others until the case comes along that is the one that needs to be solved. So I haven't had one of those, but clearly that information is stored on the phone because it's used to compare your identity at the time of login. So it's stored in there somewhere, and I have a feeling we can find it.
Right. Okay. So Julie had a question about burner phones. And Julie, do you mind asking the question yourself? I thought you could probably express it better than I could.
I can. Thank you.
Yeah.
I'm just curious. It just seems like such a dead strategy to me because it just seems like they would be so easily traceable. So what would even be the point, I guess, is my question.
For a burner phone.
For
a user to have a burner phone?
Right. Wouldn't it only be useful to law enforcement once they have it in their possession? I mean, it just seems like such a risk. Why would anyone bother, I guess is my question.
Well, back in the day when we started, 2008, 2009, burner phones were actually much more protected than they are today, right? It was like a cost reduced phone from like an LG or a Samsung. So they actually disabled the data port so that I mean, what I do when I actually extract a phone is I plug a USB cable into the data port of the phone, and I copy the entire contents of the phone onto my forensic workstation. Well, in 2008, that flip phone, it was a burner phone from Samsung or LG or somebody like that, sold through, Virgin Mobile back then, or TracFone, or who are some of the others, Boost Mobile and all those folks. They disabled the data port in the electronics so that I couldn't even, my USB cable wouldn't even work. The other thing is that the burner phone providers like Boost Mobile and Virgin Mobile and TracFone and some of the others, they don't keep good business records either. So you can't really get the text messages. If you subpoena them, you oftentimes don't get the data. So those are some of the advantages they had back in the day. Now burner phones are cost-reduced Androids. And generally the data port works. So yeah, the advantages of the sort of protective attributes of burner phones is very different from the feature phone era, the flip phone era, compared to today, which is cost-reduced Androids. But people buy them because they're cheap, and typically a drug dealer will cycle through a couple of these a week. So he's only got it for 2-3 days, and boom, next one, next. So the compelling value is the fact you can buy 2 of them a week because they're so cheap. But law enforcement gets into burner phones. We get into burner phones a lot. Sometimes we'll take a criminal defense case where we have to get the burner phone to actually exonerate the defendant. So it all depends. Every case is different. I want to talk to you about apps, and mobile messaging apps, of course, are the important ones. There's like over 100 different mobile messaging apps now. So when somebody says they want to get the text message, they want the deleted texts, well, I've got to kind of actually have a much more specific conversation, because these are some of the examples, but there's many more here. And the big kahuna is WhatsApp, which went down on Monday for a little bit, but WhatsApp is huge internationally. And what you don't see here, I don't think, is Snapchat, and WeChat is huge in Asia, which you see here, but there's just so many. Text Now, Text Free, Text Plus, just it goes on and on and on and on about all of the various forms of mobile messaging apps. And those are critically important. Every day we're working on finding deleted text messages, which are often mobile messaging apps. There's also mobile messaging apps that actually expire, right? That you can put a retention period. Snapchat is sort of like that. You should not believe that Snapchat material goes away. We data mine Snapchat all the time from mobile devices. The snaps and the memories and the stories and all those Snapchat objects or Snapchat things, they're all still there. And the same is true with Wickr, and Tiger Text is really pretty powerful. The medical community, the healthcare community has adopted Tiger Text. It's encrypted, it's pretty powerful. But there's families of these kinds of mobile messages. There's also social media, which now every social media platform now has a corresponding text message channel. So DM, right? Direct message me, DM me, and you can do that in all these different social media platforms now. And so that's when you say text messages, well, it could be an Instagram DM I'm looking for, or a Pinterest DM that I'm looking for. So it's text messaging is ubiquitous now. And even the multiplayer games, they all have simultaneous text message channels going on, both at the sort of platform level like Xbox and PlayStation, but also the individual titles like Fortnite, Words with Friends. They all have text activity going on simultaneously with gameplay. And sometimes it's the text message that matters. If you get into a game, a case where the multi-user game, massively multi-user game is actually the sort of object of the case. And social media is everywhere. And we oftentimes have to probe social media from a mobile device. Distracted driving case, sometimes we'll see quite a bit of social media, especially Facebook, Instagram, Snapchat, Twitter, that kind of situation. So it's all very important, and it's really critical to have the mobile device forensic tool or tools so as to be able to data mine all of this material and make sense of it and do it cost effectively and do it fast and do it accurately. So I think that's my introduction.
John,
any questions so far?
Oh, we've got a question for you. So we were just on the chat, just asking about a few things. So which app, is that something that you can data mine as well?
I mean, WhatsApp
No,
Messenger.
which app? WHICH?
It should be WhatsApp.
WHICH. I haven't
Oh,
heard
the
about that one.
WhatsApp?
It should
Okay.
be WhatsApp.
Joanne, sorry, we all mistype sometimes. So WhatsApp, you can mine that pretty well then, right?
Oh, yes. Yeah. WhatsApp is the most powerful messaging app in the world. It's used internationally, got its renowned experience with users from all over the world, extremely great at international and activity, and so powerful because in fact, in a lot of third world countries, it was so expensive to send a text message. And then WhatsApp came along and it was free. And there were no limits, there were no quotas, there was no costs. It just opened up texting worldwide. And so WhatsApp just kind of went to the top of the food chain. And we have a very, very powerful capabilities for WhatsApp. It's supported by every one of our tools. And we have powerful capabilities for getting live and deleted WhatsApp, as well as encrypted WhatsApp. The attachments, tons and tons of metadata. Yeah, WhatsApp is right up there. Right up there with Facebook Messenger and Snapchat.
So is there anything that's safe? that's if we're worried about being brought into court one day, which one, if we were a criminal, is there one that is better?
Well, there's a couple there that are really quite good that attempt to be secure. Signal is perhaps one of those. What else could I tell you? Telegram. There's 2 or 3, 4, 5, 6 maybe that have a reputation for security, for encryption. I mentioned TigerText before. Pretty powerful. I mean, if you know about the privacy standards in the medical community, HIPAA, right? HIPAA is a major privacy aspect to keep all of our medical information safe. In fact, there was an amendment to HIPAA a few years ago called HITECH. There's both monetary and criminal penalties for violations of HIPAA privacy regulations. And so if TigerText is being relied upon by most of the medical and clinical providers, then you know TigerText is pretty good. So if I was a professional, I would use TigerText, but Signal and Telegram are also pretty reputable and have an encryption scheme that oftentimes works, sort of end-to-end encryption. There's another one called Kik Messenger, which a lot of criminals use, KIK, started in a dorm room in Toronto, and is pretty much about the same caliber now. So Kik Messenger, you'll find Kik Messenger always is kind of, I think of that right away when I'm thinking of possibly a criminal scenario. So each one of these mobile messaging apps has sort of a story, has a clientele, has a reputation, and it's good to learn about them. All right, so what I want to show you is that this is a presentation I initially put together for post-conviction and how mobile device forensics is really becoming kind of a very, very powerful evidentiary paradigm, much like DNA was in the 80s, 90s, and 2000. Mobile is becoming that way now in the 2020 era. And so I put this presentation together initially for the American Academy of Forensic Sciences, where I'm a member, but I expanded it here in Minnesota and taught all the criminal justice lawyers about it last month in August, actually 2 months ago in August. And I'm going to share a bunch of that with you now because it's kind of powerful and does describe various sort of interesting approaches to mobile device forensics. This was the presentation. I actually deleted some of these, but not all of them. And I talk about here the emerging role of mobile device forensics, especially its power in not only finding the relevant and material evidence to potentially exonerate the defendant, but also the fact that in post-conviction work, it has to be new, it has to be novel. It cannot be the kind of evidence that was available at trial. And that's the big hoop. And what Nancy was talking about was very much that whatever the evidence was for against the defendant that caused him or her to be convicted, new evidence is required in order to have a post-conviction opportunity to get a new trial and therefore ultimately exonerate the client. And so mobile is really good at that new factor, which gets you in the door to try and prove that the defendant didn't actually do it, which is kind of what this slide says. But I'm trying to make the argument that cell phones are the new DNA, right? We need new scientific testing to open the door for wrongful conviction review. DNA has been super great forensic biology science, but now we're basically trying to say, well, now we have communications, digital science that's powerful as a scientific tool because the speed of innovation, right? I mean, a few years ago, we used to have Blackberries, right? And now then it became then iPhones and Androids, and who knows what's going to be coming next. But the idea here is that the speed of innovation and new development makes it possible to have new ways of accessing evidence off of older devices, and provides the real value is also the diversified number of proof vectors, right? There's just so much different kinds of information. If you want to know when it happened or where, or what the text was, or what the picture looks like, what the video might have been, there's just so many different kinds of questions that mobile evidence can answer. So that's the hypothesis here, is that we have a steady stream of opportunities to recover evidence from mobile devices, right? It's really terra incognita, right? Undiscovered country. 3 years from now, we're going to have capabilities that I can't even dream of in mobile devices. In fact, I have to retrain myself every 2 to 3 years and basically relearn my profession because it's so different. It's moving so fast. And therefore, if that's the case and you're looking for novel evidence that wasn't available at trial 3 years ago, welcome to mobile device forensics. So it has that capability to provide novelty as well as incredibly material evidence to try to convict if you're on the law enforcement side, or to exonerate if you're on the post-conviction side. And in general, in this post-conviction environment, we're basically talking about, well, the Innocence Project, of course, appellate public defenders, and then private criminal defense attorneys. But the Innocence Project's where it's at. I actually performed the mobile device forensic services for the Innocence Project of the Great North, which is Minnesota, South Dakota, North Dakota. So I work with them and get involved in some of these fascinating cases, and have had a blast doing that, working with them. And some of them are fabulous lawyers, especially the managing attorney here in Minnesota is wonderful. So this is the hypothesis. The speed of the innovation is critical. We're talking with mobile devices about cell phones or smartphones. We're also talking about fitness trackers and digital watches. They all apply. They're all moving at the speed of light in terms of innovation. And then the artifacts, right? The sort of the evidence types of the evidence things. Messaging is huge. We also can get activities, right? The steps you take and the distance you walk and the flights of stairs you climb. Even we can get more medical information now. We can actually get pulse and heart rate. And the device locations I mentioned before, the GPS, which is very precise latitude, longitude data. Photographs and videos are huge. Because the capacity of the devices is so much bigger now, we can get just literally tens and hundreds and thousands of photographic. If I get a big smartphone, it's going to have 500,000 photos and videos for sure. And sifting through all that's a problem. We've got great browsers now and search capabilities on phones, and then pattern of life evidence, which I'll describe a little bit later. And then the ability to utilize in our mobile device forensics tools today, both artificial intelligence and machine learning capabilities, is making it possible to deal with this sort of big data, complex data situation. So we can categorize messages and photographs and get some insights by letting the computer do the work before we start our exams. So lots of activity here, lots of things going on. A lot of the innovation we'll see in the next couple of years is going to be happening in this AI machine learning space. So cell phones versus DNA, there's some similarities and some differences. There really is a huge similarity. I'm sure Nancy would agree with this, that that both of these modalities for evidence comport with a very effective success rate in overturning wrongful convictions in the US. They're kind of standouts, and DNA has been for decades. Mobile is really just getting started with this, but it's pretty effective. But there are differences also due to speed. I think mobile's got an edge there. It's just moving so quickly. And we'll have to see how that goes. But this novelty requirement I talked about is critical. The petitioner or the defendant who's already lost at trial and even lost at the appeal does need to provide new evidence, novel evidence, evidence that wasn't available to be used by the trier of fact at trial. And DNA is great at that, as well as mobile is now. And mobile is going to probably get the edge with the accelerated pace of the development. So this is why I think both mobile and DNA is just so good at it, is everybody's got it, right? Everybody's got DNA built into their body. And everyone, of course, has a cell phone these days. And therefore, these are very powerful it's very powerful subject matter in the life of every human on the planet to look for exonerating evidence. And so this is kind of powerful. And this is why it's so important to be able to master these techniques and to be able to apply them effectively in a criminal litigation scenario. There's also destructive use cases. We can skip that and move on. This is a key point here, and that is, as I'm sure Nancy talked about a little bit, there's a lot of DNA testing that's been done over the years, and now it's done routinely, and therefore the old untested DNA challenges are now rare. So the number of possibilities to use DNA in post-conviction work is a lot less now in 2021 than it was in 2010, 2000, certainly in 1995. And so mobile is, I think, sort of starting to take the place, given the fact that everybody has a mobile phone as well. It's so populous out in our society, in the world. And there's a tremendous number of old, untested cell phones. The law enforcement tends to keep them. There's evidence lockers all over the world at every jurisdictional level, whether it's a big federal case or if it's a state case, even the counties, even the metro. You can always find an old mobile device that law enforcement's hanging on to. We've gotten them 10 years old, 12 years old. I think 13 years old is the oldest one we've gotten. And part of the problem is helping lawyers, criminal defense lawyers and post-conviction lawyers actually realize that mobile is a possibility and that these old devices are generally being taken care of by law enforcement in these evidence labs. And they can be requested and they can be utilized as potentially probative evidence for exonerations. These are when I said diversified proof vectors, DNA, right? The DNA either matches or it doesn't. So it's kind of binary, right? You win or you lose. Whereas with mobile evidence, it's way more nuanced and sophisticated, right? Look at all the different kinds of questions. GPS metadata on a text message or a photo or a video or a Wi-Fi connection. It can answer the question of where, when. The when is the timestamp. The where is the lat longs. How high? With GPS, we get an elevation. It's not just a latitude, longitude to locate them on the planet. It's also whatever the elevation might have been. And sometimes we get velocity with a GPS track point. Photo and video evidence, same thing, because guess what? Inside every photo that you take with your iPhone or your Android and every video you take, there's a block of data called EXIF data. And that EXIF data has date and time stamps in it, and it has GPS coordinates in it. And so photo video is just answers every question in the book. Contacts, of course, answer who. That's kind of a duh. Messages and email, you can get all of the communication and all the metadata that comes with the communication. Voice messages are still found on phones, very powerful, especially if they're deleted. So lots of potential questions that can be answered with mobile evidence. And here's the point, if you're doing post-conviction work or criminal defense work, guess what? The defendant's going to cooperate with you. And that is huge. Law enforcement has huge problems trying to bypass passcodes or recover passcodes, whereas criminal defense lawyers and post-conviction lawyers don't have that problem. Because what? The convicted defendant is going to tell you what it is. And so the Fourth and Fifth Amendment are easy for criminal defense and post-conviction lawyers to bypass. Whereas if you're a prosecutor or you're a detective, you're never going to know what the password is. So you have a much bigger challenge. It's one of the few things in criminal justice that I think goes the way of the defendant. Also, sometimes mobile devices go missing, and we like to look at the cloud account that goes with it. If an Android phone is somehow gone, it's been lost, it's been destroyed, we right away want to take a look at the Google account that is attached to or synchronizes with that Android phone. Same thing with Apple. If there's an iPhone that's gone missing or it's been destroyed or what have you, we want to look at the iCloud account, because oftentimes the information is synchronized to that iCloud account. And so that's really critical for us there. A big difference. We have sort of backups or safety nets that we can go to. Lots of different points here. I guess the main point here is that mobile device forensics has a little bit more of variation in terms of the skill sets. typically DNA labs, you've got accredited DNA labs with all kinds of professionals running around. They do a really high-end job. Mobile device forensics is a bit different. You may have a federal facility or even a state forensics lab that's top-notch, but then you may actually get into the somewhere in the hinterland, right? The outstate environments. You might find some mobile device examiners there who are just getting started. They're kind of newbies, and you may have a much less quality outcome, so to speak. And so there's a possibility that that can be a real angle for in post-conviction work if the work wasn't done properly the first time. So there may be a slight difference there in expertise. And then of course, there's all kinds of glitches that might happen. And so you can actually exploit glitches. If there was some glitch that happened with a flip phone back in 2009, and that can be overcome now in 2021, it's quite possible to actually extract that phone and get the evidence deeply probative, and then be able to actually have new evidence that was incapable of being recovered 10 years ago because of the various challenges. The glitches were overwhelming 10 years ago, but now we can easily deal with them. There's also a problem though, and it's probably the biggest problem that we have in post-conviction work, which is it's really hard sometimes for the lawyer in the sort of the well of the court to convince the jury that that cell phone was in the hand of the defendant. If that cell phone was somewhere else, then the timestamps and the location data and all the rest of it may not attach to that particular user's activity. And so it's really critical, and every attorney who actually argues needs to try to show the sort of singular attachment between that phone and that user. To the extent that that actually gets separated, then you don't really, it's much more difficult to weave the story. This user activity that we had this phenomenal evidence for may not actually represent what that user was doing. So there really is a sort of a underlying critical factual pattern that needs to be established at the beginning and through the duration or pendency of a particular evidence stream that is attempted to be admitted into court and then to argue for exoneration.
John, we've got a courtroom question just about, so here it is. So if you're a defense attorney, you get the phone from the police. I'm assuming the prosecutor has rights to the results of that as part of discovery, or no?
It was the other way. The state has so many advantages in American jurisprudence, criminal jurisprudence, right? I mean, there is the government funds forensics labs for computers and mobile devices and cloud and cell towers, and so there's extraordinary lifetime professionals that do the job for 10, 20, 30 years, and they have great salaries and they get great training and everything. You have this incredible infrastructure and organizational construct that the state has to do this all day, every day. Mm-hmm. What's the defendant have? Zip. They don't even know who to call, right? There's a few of us who do it privately. There's some public defenders out there, but they have low budgets, and your average public defender's got 100 cases, which is so far beyond what the American Bar Association says a lawyer should have for a caseload. There is such an imbalance between criminal defendants and the state. So in fact, the Supreme Court said back in 1963 in the Brady case that the state has an obligation, has a duty, that when they find exonerating evidence, they have a duty to share it with the defense. It does not go the other way.
Oh, okay, thank you.
Yeah, so we have all this language in the law, in criminal defense law. If you think you're not getting if you're not getting the evidence you need from the state, you'll write them a Brady letter. There's a lot of that the defense really has to work hard to get evidence out of the state, because the state has financial and staff and infrastructure advantages over the defendant. So that's how that works. But the defense team has to work really hard. Sometimes you have to ask 1, 2, 3, 4. I've asked 4 times to get the information. And then each time I get a little bit, that just lets me see there's a little bit more that I can ask for. So it's a struggle. It's hard. Okay, GPS. So GPS is really interesting. That it is a problem. It's wonderful to get this GPS information, but you kind of have to make sure you know what it means. And it turns out that we now can harvest so much GPS information on smartphones that we have to make sure that what we find is actually a place that the phone has actually visited. Because sometimes there's GPS information that can be found on a phone that is not where the phone has been. A couple of examples. There is a certain kind of GPS data on an iPhone that's called a learned location. And that is the particular user visits this place so often that the phone kind of knows that it's there. It becomes like a waypoint. The phone records the fact that this location is so frequently visited, it puts it into a separate category. And it's important to know that on a particular day and time, that learned location may not have been visited, and yet it's still stored on the phone. So that nuance needs to be discerned by the examiner. Also, iPhones with the iOS operating system are constantly trying to predict where you're going to be going as an iPhone user. So there's a whole predictive or anticipatory GPS scheme going on inside the phone. And if you're a mobile device forensic examiner and you tap into some of those points and you think the phone actually visited those points, you may be sorely mistaken. So careful interpretation and expertise is needed to sort through the various flavors or colors or categories of GPS to make sure that you've got honest to God GPS that indicates a real significant visit by that device. There's also other forms of passive evidence creation by a smartphone operating system. For instance, photographic thumbnails. So you may actually snap off a picture of the family, right? But you didn't notice 7 thumbnails got created or maybe subsequently created. Sometimes they're photo reduced for different reasons on iOS or Android. But sometimes artifacts get created by the device that were not created by the user. Another example I have here is file activity and logs for incoming data, right? Email comes in, all kinds of messages come in, social media stuff comes in, and you really need to be able to discern which artifacts on the device that may have a latitude, longitude GPS, may have date and timestamps, which of those actually are part of user activity as opposed to the operating system doing what it does. It takes that level of nuance to be able to tie the evidence to human or anthropomorphic activity. That is a big mistake that people like me can make. And so we're constantly aware of that and can, in our reports, our findings to the court, we've got to be very careful to make certain that what we find, that it ties to user activity and not the operating system doing its shtick. These phones are like little animals. They're alive. They're doing stuff and they're doing smart stuff and they've got AI in them now. And they're trying to guess what's going to happen next because they're trying to be smart. And you don't want to be ascribing evidence to a phone or to a user that actually the phone was up to that particular activity that caused that phone evidence to be stored. So it's something to watch for. So this is kind of a shift. So the idea is, how can we use mobile devices to help defendants in post-conviction cases? So I talk here a little bit about the artifacts, right? So when we use device locations or track points, that's perfect for an alibi. If you can actually get the track points to show that those track points were visited by the phone and that the defendant had the phone, then it's an alibi, and alibis are huge. Photos and videos, same thing. You get the location information and the date and timestamps in that EXIF block inside every photo. Well, you got a built-in alibi. I mean, I sometimes joke with attorneys when I teach them in continuing legal education sessions, just keep a running photographic library about where you go. You're gonna have a get out of jail free card if you've got a whole bunch. If you take a photograph every 10 minutes of where you're going and when, and you keep it on your phone, you've got proof. We oftentimes go looking for photos and videos to grab the location and date and timestamp information to look for alibis, and especially if the location, if the pixels, if the photograph itself ties beautifully with the location, right? You get a picture of a a known a known location or attraction or a known whatever it might be, street sign, what have you. So if the photo content jives with the latitude, longitude, and it jives with the date and timestamp, that's the best get out of jail free card you can possibly find. Wi-Fi and Bluetooth also can go to location and alibi. Oftentimes a Wi-Fi and Bluetooth we can determine the location from those and then get the date and timestamp from those, and we have an alibi. Communications, of course, messages and chat, voicemails and mail, those are all communication. Activity and health, go to motion, go to status, proof of life. iPhones are incredible at activity and health information. You might not know this, but by default, your iPhone is set up to be constantly monitoring your steps, your distance, your flight of stairs. And if you got an Apple Watch, it's also by default, it's going to be sending the heart rate and pulse information to the iPhone that it's paired with. And so lots of activity and health information, which is super valuable for all kinds of cases, whether it's a distracted driving case or a sometimes personal injury cases, of course, and even medical malpractice cases. And then browsers and search, right? Oftentimes browser and search is used on a computer, but way more often it's used on a phone. And then if you've got Google searches, you can really get into the motive and intent, which are critical factors in criminal law, looking for the criminal thought process that goes to the degree of the criminal intent or activity. So lots of different artifacts. Also, there's pattern of life evidence, which is relatively new the last couple of years. Pattern of life evidence is a term of art now, and it goes to these insights into digital behavior, right? Habits and routines in day-to-day life that we can pick up on mobile devices if we get a really probative, deeply probative extraction. Here's a bunch of examples. The phone now actually keeps track and keeps a record of when the phone gets powered on and powered off. That's pretty powerful. If you know when the phone is off, you know not to look for any evidence. The use of the battery, if the battery's going down and the battery dies, you can actually watch that happen in the timeline. Lock screens are huge. The iPhone keeps track of when it's locked and when it's unlocked. It also, with the various sensors inside the phone, the gyroscope and some of the other sensors, it actually knows if it's in horizontal versus vertical. And it knows when it switches from one to the other. That's pretty powerful. If you've got a distracted driving case and you know that the phone is moving from one to the other, it's in the person's hand and they're using it, right? They may be unlocking it. If you've got device orientation changes coupled with a lock screen and unlock, wow, you're in like Flint. And then there's device connections. So if the phone is connected to a Bluetooth in a car or Bluetooth with a headset or Bluetooth with something else, we can figure that configuration out. Or if it's connected to Wi-Fi, if it's a vehicle or a watch or a fitness tracker. So all the connections between the smartphone and these various other devices help us understand what other capabilities might have been in use. And then, of course, we can look at the Wi-Fi and cellular to know what kind of data is coming in and out of the phone and how. That can be very powerful. And then the new capabilities, the last year or so, screen time on an iPhone. There's a wealth of measurements, metrics, and statistics that one can find from the last 30 days using screen time on an iPhone. The comparable capability on an Android is called digital well-being. And those statistics can be really powerful in court, especially if you can harvest them quickly enough so that you can get the full 30 days, or sometimes you can only get a week or two, but if you can get it, it's good to get it. Letting a whole month go by with a mobile device is probably the worst thing you can do in terms of not being prompt about its timely extraction, so as to capture a lot of this evidence that expires ever quickly.
Hey, John, we have a quick question about geographic stuff. So mobile location data, it used to be that we'd look at cell phone towers, right?
Yes.
So you can look through those records to find that information in reverse, right? To corroborate where people are.
Well, you need tools to do it. It's very complicated and it's very imprecise.
Oh.
Yeah. You're gonna get a switch, a tower number, and then the antenna up on top of that cell tower, which is 120 degree sweep. And then Lord knows how many miles it goes, but you're just guessing. You may be looking at square miles of activity where that phone might have been, because all you really have is the tower and then the sweep. So it's I used to call it junk science for years and never practiced it. There's been a few innovations that have made it a little bit better now. We have a little bit more information about how far out from the tower the radio frequencies might be, but it is very imprecise evidence. GPS is the gold standard. Which I don't think was your question, however.
Well, no, well, I think it was about cell towers. No, that was
Mhm.
you answered
Yeah,
that.
I was just wondering if you could do like a reverse lookup with the cell tower to find that. info
Reverse
in reverse.
lookup. So what would
Yeah.
that be?
If you happen to know where the cell phone was, or you're
Uh-huh.
not, and then you find the closest cell tower and just make sure that you're corroborating that evidence that that was off that cell tower as well.
Oh, well, the problem is that sometimes it isn't.
Okay.
There's most people assume that the closest tower is servicing the phone, and sometimes it's very much not the case. Sometimes a tower can completely be saturated, and so it's giving up all of the nearby phone calls and text messages are going to another tower, because the tower may be down or it may be saturated in terms of its capacity. So many times a tower is servicing a phone that is not the closest one. And typically it's the case that the law enforcement doesn't know where the phone is. And so they actually go and get the business record from Verizon, and it says that it's this particular tower and this is the sweep. And so good luck, there may be 10 square miles in that 120-degree sweep from that particular antenna if it goes out 5 miles. In the city, of course, it's ambiguous. Sometimes you may have a piece of geography that actually is in the sweep of 6 different towers. And so it becomes really hard to establish the fact that you weren't somewhere in the city. It's easier out in the rural sometimes, but it's really junk science compared to what you can do with a smartphone and a satellite navigation giving you a GPS coordinate. So when we get calls to try and do cell site analysis, we almost always turn those into mobile device forensics jobs, because you get maybe 10 to 20 times more qualitatively different kinds of evidence, and you have the chance to get GPS as opposed to these just dramatically imprecise cell site analysis information. So let's see. So let's talk about sort of how in a post-conviction kind of situation, what you can do. I talked a little bit before about feature phones and flip phones and burners and the glitch thing, right? Back in the day, we oftentimes couldn't even connect the old phone to the forensic workstation to get an extraction. Today, we can actually much more effectively actually do that. We can overcome the glitches. And so that becomes, there may have been a defendant that had a flip phone and the law enforcement couldn't actually connect. And so it was never even analyzed ever. Whereas now it can connect and we can analyze it. What they used to do when they couldn't actually connect to a phone to extract the memory and make sense of it, they used to just photograph the screens. But oftentimes they'd miss a whole bunch of screens, or they'd just rush through it because they had quotas. So there's the potential to connect to the phone when they didn't used to be able to do it 10 years ago, and then to get real digital evidence as opposed to just screenshots of screens that may have been taken or may not have been taken. So it's pretty powerful. The other thing is, if back 10 years ago, the examiner inside the police department took 90 pictures of screens, they're just photographic information. You can't search them. You can't text search them, right? You can't do any kind of searching to find particular forms of evidence. You can't use keywords. You can't filter. They're just photographs. And so flip phones are really prime. Feature phones and old burners are prime pickings to get post-conviction opportunities, given to all the advances now we have in that particular area. There's also these hardware techniques I told you at the beginning that we can use. There's 3 of them: chip off, JTAG, and ISP. And these are kind of powerful capabilities to extract the memory of a flip phone or a feature phone or an old burner phone that weren't available 10, 12, 15 years ago. And we've done quite a few post-conviction cases, Innocence Project cases, where we go get a chip off, and we get a physical image, right? All the bits and bytes in the memory of that feature phone, and then we can extract it using our tools, and we get all the text messages live and deleted, we get the photos, we get the calls, and it's a whole new world, which fits the legal requirement to get into court on post-conviction, and then you've got the material evidence when you get there. So the old cell phones, the old burners and flip phones, using these techniques, as well as some of the ones on the previous slide, are prime time for post-conviction. This is truly the DNA scenario. But there's something else. And I always thought, it's great to have for Innocence Project cases and appellate public defenders, and occasionally you get a private criminal defense lawyer working on a post-conviction case, but it's always the old cell phones, the old stuff. What about something new? And it turns out that we now have a use case or a scenario where we can do the same thing with iPhones. Why? It's because we had a renaissance in 2020. The first 2 or 3 months, just right before COVID, we actually got the ability to do amazingly probative extractions of iPhones for the first time in 10 years. For 10 years, when we got an iPhone into the lab, all we could do, because Apple is so private and secretive, and it's so hard to get anything out of an Apple iPhone, all we could do was get an iTunes backup. That's all we could get, and we would data mine that looking for evidence. And it was a superficial backup, not probative. We could get text messages, not very many deleted, not much at all, really. And so for 10 years, we did superficial work with iPhones. Now for a year and a half, we get these deeply probative iOS full file systems we're getting. And that changes everything. So this is one of the opportunities we have for post-conviction work, is we can do a novel, new, deeply probative extraction of an iPhone that may have been looked at 6 years ago. And now the defendant is doing life without parole. We can get a full file system. We can find extraordinarily marvelous forms of evidence, pattern of life, GPS, deleted texts, and we can exonerate. And it's pretty cool. The other is, there's also a similar tiny renaissance that happened with legacy iPhones, the really old ones, iPhone 4, 5, 5C. We can actually get a physical image of those now using much more modern mobile device forensic tools for these particular old models. And we can unlock the passcodes, and we can do it pretty quickly. For the old 4-digit, like this old one here, this old iPhone, it's got a 4-digit passcode. We can actually go through and do a full brute force password detection, and then we'll find it in 12 minutes. If it's 6 digits, it'll take us a day, but we can still get it. And then once we do so, we can get a physical image of that phone, which means we get everything live and deleted. And so we're in this brand new world with iPhones. And so we've got 10 years worth of iPhones that law enforcement holds on to in their evidence lockers that we can now image and decode and get extraordinary amounts of new evidence, which satisfy the novelty requirement to get into court for post-conviction. And once we get there, do we have some a cornucopia of new digital evidence to admit for a new trial.
Hey, John, here's a question for you. And I'm not quite sure how to word it, but it sounds like, so if you're a defense attorney and you have access to all this information, are defense attorneys actually finding that this is proving their clients innocent, or is it convicting them more? Does that make sense?
Yeah, it does. Well, it does if the state, in a post-conviction scenario, if the state gets busy, if the state actually, there's such a backlog inside metro police departments and county sheriff's offices. Last thing they want is another phone.
Yeah.
They have quotas. They can only spend so much time on a phone. They're done.
Oh, wow.
Where that's the beauty. I said it on the earlier slide. I didn't talk about it, but private forensic examiners, people like me, if I have a case where we have a fair amount of funding, I can spend a lot of extra hours that the state's not going to spend. Or if it's an Innocence Project case and I'm doing it as a public service and I spend a lot of extra hours, I use 3 tools instead of 1. I spend some extra hours late for work on a weekend maybe. I can dig deeper and possibly go much further than the state would go. And so there's a built-in advantage there that the defense might have as compared to the state. But if the state is on the job, if they're careful, if they're doing a thorough job, and a case comes up like this, they have the same power to do the analysis. If they do the work, they might just win it if they find something that might be more inculpatory as opposed to exculpatory for the defense. But it doesn't usually happen.
Okay.
So yeah, it's an the open opportunity is there. Law enforcement has all these tools. The question is, are they going to use them?
Okay, great. Thanks.
Smartphones, the same story. There's all kinds of new innovations for Androids as well to get physical images of an Android phone that we never could before. We always had these Android backups we were using. It's not quite as bad as the iPhone. There's also encryption issues and security patch issues that we constantly fight with Android. And we have new tools now that can bypass some of that. So we might get an old Android phone that we can now actually work with that we couldn't work with 8 years ago, and now we can. And same thing with burners. Burners are sometimes hard to find. It's even sometimes hard to identify a burner. We had one a couple of years ago, and we finally found out it was a Metro PCS. I can't remember exactly how we did that, but we actually called a couple of Metro PCS stores, and we found this really brilliant Metro PCS salesperson who was like very technologically sophisticated, who helped us to identify which make and model it was. And as soon as I had the right make and model, I could actually go into my supported phone list for Cellebrite UFED and figure out exactly which extraction to use and which cable to use. And I got a physical image of that burner phone, that Android burner, because of the help that I got from Metro PCS. So there's just all kinds of different angles to the jungle. And if you're resourceful and if you use all the available information you can get and you think outside the box, sometimes you can bring it home. It just depends. And when you get those breakthroughs, it's like gold in post-conviction cases.
Wow. Okay, we've got more questions. So thank you, John. This is a beautiful can of worms you've opened for us. So can a a bad guy, right, who's really technologically adept, can he go in and create fake data on a phone to frame someone? Is that possible?
It's really, 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 really hard. It's not impossible. You have to have advanced capabilities, advanced knowledge. Hardly anybody ever does it. But it's possible, but there's just like, people don't know how to do it. They really don't. And most of them, if they would try, it would not be compelling because everything else would be completely inconsistent with it. And we do that. We actually look for inconsistencies all the time. We're constantly looking for fraud and tampering and intentional deletion or destruction of evidence. So if it doesn't tie together, we're going to find out. So we're really good at that. I would say 20% of our cases go to either fraud, or the term of art in law is spoliation. The intentional willful destruction of digital evidence, spoliation. We look for that all the time. And we look for photographs that might be tampered, that deep fakes, you've probably heard of deep fakes. We actually have another professional that we work with who has the best tools on the planet for picking those out. And so we'll shoot, for certain kinds of cases, we will send our photographs off and he'll come back with a full analysis of the likelihood of that photograph being either tampered with or being completely, photoshopped or modified by some kind of photographic or video editor. So it's really pretty tough to work up factually incorrect information on smartphones. I have yet to see it in my lab, but somebody like me would be the person who would actually probably try and do it, and would probably fail because it would not be fully integrated within the device. It would be hard.
Okay, great. So one more question. Sarah has a really good one. So our new phones nowadays, you get a new phone, you just transfer everything from your old phone to your new phone, all the apps, everything transfers over. So what about deleted data, that hidden stuff? Does that deleted data transfer from your old phone to your new phone?
It's hard to say because each make and model of a phone is different. Certainly iOS and Android are completely different. So there would be no way to make a common answer for the two of those. But even iOS changes from 14.5 to 14.6. iOS behaves differently. So it's really hard to keep up with the sophistication of the functions that happen in new releases of the operating system. And it can be different for like an iPhone XS versus an iPhone 12 coming out with 13. It's just the hardware platform and the individual iOS operating system make it really hard to make sort of black and white answers to questions like that. It used to be back in the day when you would upgrade from a phone to an old to a new, you would do it in the Verizon store or at Best Buy, and they had some hardware that would do it. Now most people upload to the cloud and have it come back down from the cloud on the new phone. It's not clear exactly what gets moved. It might be depending on the settings that you use. I would say in general, the likelihood of anything deleted moving over is probably pretty low, but I have not done the experiments. As scientists, digital scientists, we pretty much actually do experiments before we answer questions like that. And then we qualify the answer to the particular make and model of the device, the particular operating system, and maybe even the even more factual information in that particular scenario. There's no easy answers in this field, unfortunately. And then the opportunity to have the time to actually do those experiments. I mean, I have a list of experiments that I would like to do sometime that's as long as my arm. Digital watches, given my time, I think I'm going to skip some of this. Digital watches, yes, there's lots of cool ways you can use digital watches to get new evidence. Same thing with fitness trackers. But I want to get into the case studies. This was our post-conviction case study. Murder in the first degree, attempted murder in the first degree. Naja Nix was sentenced to life without parole. And then he did a petition for post-conviction relief. It was denied without a evidentiary hearing in 2011. But the court agreed. This was the court here in Minnesota, Supreme Court in 2013, that did allowed for an evidentiary hearing to happen. We actually had a chance to do the work to get ready for that evidentiary hearing. So we did lots of work, mobile device forensics work. We worked closely with Minneapolis Police Department. Great opportunity to work with them. It was very compatible working with them. And this was an old flip phone. And there were problems. It was originally photographed, all the screens were photographed. We were never able to get an extraction. So we did a chip off, and then we got the extraction of the phone. We recovered new call log evidence that made all the difference in the world. It revealed materially new facts about the calls. Turns out the calls never went through. The defendant never actually talked to the victim, and yet the conviction was entirely based on the fact that there was a conversation that happened between the defendant and the victim prior to the murder. And the new facts contradicted two eyewitnesses who lied. So we had a 2-day evidentiary hearing. I got to testify. It was quite cool. Judge Koch was fabulous. Former assistant U.S. attorney, former JAG, a lawyer's lawyer, great judge. So we got a request for a new trial. And so Mr. Nix got a public defender. He was able to actually do a plea bargain. And he got it down to murder in the second degree without intent while committing a felony. So the evidence was powerful, but he still had a few years to do. So he had already served 205 months. He had to serve 205. He had credit for 106. And he was released on parole in July 1st, 2019. Life without parole, and then a July 1st release in 2019. So this really can make a difference. Two phone calls on a flip phone back from 2008, I think it was, can make a difference, huge difference. In this case, the value of it was chip off and then getting those phone calls and then properly articulating it into court. Another case, this Ferguson case, I did this one like 12 years ago. It was a public defender case. And this is the classic alternate perpetrator case, right? Somebody else did it and we proved it. So there was a shooting death, and Calvin Ferguson was charged. And then at trial, the judge didn't allow the evidence to come in to suggest that there might have been an alternate shooter, right, an alternate perpetrator. The prosecutors didn't have any physical evidence. That usually goes to the fact they didn't have the gun, right? There were some questions around what the eyewitnesses, did the eyewitnesses have a good positive identification or not? It wasn't clear. So he was guilty of first-degree murder. The judge sentenced life without parole. So Ferguson is basically done. He appealed. The Supreme Court found that the lower court erred because the judge denied the foundational evidence pointing to an alternate perp. So the Supreme Court reversed and remanded for a new trial. All right. So what was the foundational evidence that was denied by the judge? The victim's phone address book contained a contact name for CJ, and CJ was an alias that Calvin Ferguson used. That was the basis upon which he was convicted. But those initials, CJ, also matched the initials of Christopher Jennings, who was another person, an acquaintance of the victim. And in fact, in the victim's phone, there was a contact record showing CJ, and by that, Christopher Jennings, not Calvin Ferguson. So there's two CJs in this victim's life, right? Who did it? Well, the original court got it wrong. So I got into the cell phone and I found call logs showing that Jennings, the new CJ, the alternate perp CJ, actually placed calls to the victim only 3 days before the shooting. The tattoo is cool, but I didn't prove that. What I did prove, and I didn't prove the fact that Jennings' physical description was similar to the shooter. They were very, very identical people. Jennings drove the car. I couldn't prove that either. But what I did do is I did a reverse phone number lookup in the victim's phone book for Jennings. And then we did a subpoena against that to authenticate it. And we actually showed that CJ Christopher Jennings was the perpetrator of this crime and not Ferguson. That one was really interesting. One of my first cases. This next case was also early in my career and was kind of unbelievably amazing. It was a class action civil suit in federal court down in Atlanta in the Northern District of Georgia. And it was against the Atlanta Police Department. It was a major, major civil rights case. Lots of civil rights abuses occurred, and a number of Georgia torts were committed. Excuse me. They were basically assaults. What happened here was the Atlanta Police Department, the Vice Squad, raided a gay bar called the Atlanta Eagle in Atlanta. And there were lots of issues that occurred, false imprisonment, a lot of violence happened during the raid, Fourth Amendment search and seizure violations, lots of issues. And so what ultimately happened was the police department had to give up their mobile devices for 22 of the officers, 26 different mobile devices. They did a superficial extraction of each one, only the live data, the logical data. They didn't do a deeply probative extraction, nothing deleted. So I got the 26, was it 26? Yes, the 26 mobile device extractions from the police department and analyzed all of the interactions between these officers. I found uneven deletions of text messages. So I found, gosh, of 26 of them, I think I found about 25 of these phones had deleted text messages. And I didn't have the presence. I just knew that they weren't there. And there was one honest cop. And I saw all of the interactions that cop had, the honest hero cop, because he didn't delete his text messages, all of his compatriots had. And so I was able to show massive destruction, willful destruction, intentional destruction, spoliation of text messages by a whole bunch of the officers because of the presence of the one honest officer. I found gaps in date and timestamps, which indicated that photographs that were taken during this unlawful raid at the bar had taken place, and a lot of the photographic evidence had gone missing. I found call log problems, and I found discrepancies between what the officers testified to on the record in depositions as compared with the evidence that I got off of those even superficial extractions of the devices. The bottom line was, and this is what enraged the federal district court judge, these officers actually deleted the phone evidence after he approved a court order to produce the phones, the officers to produce the phones. That was kind of the tipping point. So this was Judge Batten down there in the Northern District of Georgia. He said there's no way there's no data relevant to this case on those electronic devices. That's just not the way the world works today. So it was Calhoun versus Pennington. So the case settled, the magistrate judge and the district court judge, it settled in like, I don't know, 6 weeks. And the victims, the petitioners got over $1 million in damages to share amongst themselves. And the police department went under federal district court observation and monitoring for 3 years because they had to make policy reforms within the police department as overseen by Judge Batten for 3 years, which actually has never happened before in any case except for where the Department of Justice went after the municipal police department. That's the only scenario in which that ever happened. 2 other prior cases, the DOJ went after the police department, succeeded in court. But this was a ragtag team of volunteers, and I was the device examiner for it, that we did as well as the DOJ did with this particular municipality. And it was all in the phones, a lot of phones, right? 26 mobile devices for 22 officers. One brave, honest, upstanding officer is what made that case happen. Let's see, can I squeak in one more? So the rest of my cases are distracted driving cases. And this is a case where a young woman in college it was a texting while driving case. And she did text for about an hour with her boyfriend on the phone. But after she stopped texting, she was on a cloverleaf, an overpass. And then there was a collision with 2 motorcycles and her car. There was a death and a permanent disability. And the question was her texting while driving activity the proximate cause of the accident? And lots of things happened. We took a look at the 911 call to get the timeline right. She received her last text at 11:57. The 911 call was 59. So 2 minutes between the last text and when the 911 call, which is pretty much indicative of when the accident happened. This is what the car looked like. And you see a very powerful point here in this picture. You see this is a Garmin GPS unit that was in her vehicle. It turns out her old flip phone did not have a good record of text messages in it because the state did not charge the case for 6 months. They did not impound her phone, so she just kept using it. She was a college kid. And so the messages from that time period were long gone. But she had this GPS unit with her, and that was very powerful. So we went to the Verizon records, and we got the last 3 texts that she sent. One was sent and two sent and 1 received. The last one was the received one. And then we went to the GPS from her GPS unit, and we correlated the location, the latitude, longitude location with the time from Verizon. We kind of put that together, and we generated this demonstrative exhibit, which showed where she was when she sent 2 texts. If you see at the bottom here, these push pins, these yellow push pins here at the bottom, this was the first text that she sent. And then if you go up here a little higher is the second text message she sent. And way over here on the on-ramp is the third. And that's the one she received. We don't think she even saw it or read it. But she basically went down Highway 94, turned around here at this little, the state troopers normally cross over. She crossed over there, went down, and the accident occurred here. And so the bottom line here is that we were able to show that roughly 2 minutes passed when the texting stopped and the accident occurred. And therefore, the state was trying to show gross negligence on her part, which would put her into jail for 5 to 10 years. She only got a month because we were able to separate the time period from when she was texting and when she wasn't. And that's what the good GPS data can do for you. But I see that it's 4:02 and I think my time is up. Is that correct, Amanda?
Alas, it is. It is. This has been so interesting, right, everybody? I mean, I feel like I need to watch the recording and slow it down and just,
Yes,
I'm not a
yes.
scientist, right?
Too much material.
But fantastic material. I thought that was so interesting. I didn't understand how important it was that, newly discovered technology, how you can retry, convict. I didn't understand that could happen. That's so interesting. And what is it?
Yes.
It's spoliation.
Yes. It has nothing to do with spoil. It's
Right.
not, spoil is not the root word. It's spoliation, SPOLIATION, intentional willful destruction of evidence of any kind, but we use it with digital evidence all the time.
Okay.
And all of these techniques that I described and all of these interesting vagaries with evidence on phones, a lot of it applies in a post-conviction context, right? The defendants lost a trial, lost the appeal, and now is just kind of do life. But all of these techniques and capabilities and tricks and tips and resourcefulness and all the rest of it applies at trial for both the state and for the defense, and it can apply to that same record of evidence at an appellate level. So this is all applicable for trial, for ordinary defendants and plaintiffs, and for ordinary trials that happen every day that lawyers, both prosecutors and public defenders and criminal defense lawyers will use. All the same goodness is there, and the same techniques are available.
Oh, amazing. Well, bravo. Thank you so much for taking your Saturday afternoon and sharing that with us. It was fantastic.
Thank you. I really appreciate all the questions.
Yeah, so good. All right, John, we will let you go. Thank you so much.
Thank you, everyone.
Very cool. Okay. Oh, right? Like I know we need to sleep on it and come back to it tomorrow and try to figure all that out. All right. Well, it's been fun, everybody. So I think our next academy is, I think the 23rd, we're doing Detective Academy. Does that sound right? Yes. We've got a bomb guy coming in from Jersey and another Jersey guy doing an interesting murder trial and a scent trailing. Oh my gosh. I'm so excited for that one because awesome. Anyway, fun times. Thanks. You guys have a great Saturday and yeah, see you next time.
So I just want to say before you go,
Please.
this whole thing has been way beyond what I thought it would be.
Oh,
and it's
good.
fantastic. Thank you so much.
Oh, you're so welcome. It was fun for all of us. Yep. All right. Okay. Thanks. Have a good weekend.